versus Old Republic National Title Insurance Company. Mr. Kratovil.
You did a nice job with that, Your Honor. It's Kratovil. Tough name, and I appreciate the pronunciation.
Thank you. Please proceed.
May it please the Court. Chris Kratovil for the appellant and cross-appellee, PHH Mortgage Corporation. This appeal today comes before the Court in a bit unusual procedural posture, as both parties agree and urge this Court to hold that the District Court abused its discretion by sua sponte dismissing this case without prejudice for lack of a required party under Rule 19 and Rule 12b7 of the Federal Rules of Civil Procedure. Now, the trial court engaged in this sua sponte dismissal because it perceived my client PHH's breach of contract lawsuit against Old Republic Title Insurance as not a breach of contract action under an insurance policy, but rather a sort of stealth suit seeking slander of title or trespass to title under state law. And the district court believed that because this was a title action, a quiet title action in its view, it was being asked to adjudicate ownership of real property, and that it could not do so without any party with a potential interest in that real property being present, making that those third-party potential owners required parties under Rule 19. Now, in our view, in the view of both parties, that's not what is happening here. PHH has sued for money damages under a title insurance policy. And this is a bit analogous, Your Honors, to an election of remedies situation. It is possible that my client PHH could have brought a quiet title action.
Are there other parties who possibly may have title in some or all of the land at issue?
Your Honor, I think that's an open question, and the district court, in its opinion, did not advise us or this court of who the required parties might be.
Well, would the district court be required to do that? Or, I mean, isn't this basically a core dispute over what land was conveyed and what land was not conveyed, and therefore covered by Old Republic and not covered by Old Republic?
I think the second part of Your Honor's question is the salient part. Is it covered or not covered?
How do we get to the answer to that question without knowing the full universe of potential land or title holders?
I think what the court needs to evaluate, so let me put it this way, Your Honor. Whether someone else owns this land or not is not the question before the court. The question before if the answer is anyone other than PHH owns that land, then there is a breach of the title insurance policy.
Yeah, there's a reason you get title insurance. But I guess to get to the bottom of that question, the court also, or someone has to get to the bottom of what was conveyed initially by the Boykins and then second by the Boykins, right? So if it's not all conveyed, though, potentially wouldn't there be some title holder whose interests are adverse, as the district court found?
I don't think there's a danger, Your Honor, of a res judicata or collateral estoppel bar descending on a third party who's not a party to this action. Because while the court is being asked to evaluate, the district court, I mean, being asked to evaluate the effect, if any, of the November 16th, 2008 second gift deed, which my client views as a corrective instrument, correcting the October 1st gift deed, that would not be binding on a third party. That question can be answered without impacting real property rights because this is a breach of contract lawsuit. That question, there's no collateral estoppel or res judicata impact on that third party based on the.
So the question really isn't, does PHH hold title to this parcel? The question is, well, Old Republic and PHH can work out our contract dispute via the courts or what have you, and then PHH can be sued by the rightful owners of the property later? Or, I mean, it just feels a little weird to leave it that open-ended, right?
I don't want to speculate about future litigation because I think, you know, on the face of the record, it's pretty clear there'd be limitations issues with bringing a quiet title action at this point. And also there'd be questions about—
You're just saying that's a separate question, separate inquiry, and we don't need to answer that it can just hang out there.
That's exactly correct, Your Honor. It's an inquiry for another day, and it's a day that may never come. Because to go back to my analogy to a choice of remedies or election of remedies, I think PHH, when it discovered this defect in its title, could have gone two paths. It could have brought a quiet title action with the alleged owners of that property, or it could have taken the straight line out of the maze and sued its title company, its title insurer, under a breach of contract theory. And that's a much cleaner, simpler solution. As Your Honor indicated a moment ago, there's a reason people buy title insurance. This case is the reason people buy title insurance. And rather than having to go through real property litigation against a potentially innocent third party, bona fide purchaser for value, it's much cleaner to sue the title insurance company under the policy.
Also, then the fight becomes PHH's contention, there's a problem with the title, there's a cloud on it. Old Republic's contention, no problem at all. The first gift deed or what have you conveyed the parcel, and this is clear, no liability. But shouldn't we remand that to the district court if we agree with the parties that the Rule 19 analysis was flawed?
Absolutely, Your Honor.
Would the Rule 19 analysis still be salient? In other words, would we just send it back and say, well, you didn't go through the 19B factors, you didn't really, you just sort of sua sponte dismissed, you didn't let the parties have it, whatever, send it back?
I think both of those options are on the table for the court today, but I think the cleaner path would be to simply conclude that this is a breach of contract action in which only money damages are sought. The district court is not being asked to make a determination of who the owner of these two tracts of land are. And just to put this in context, Your Honors, we're talking about a 1 acre, approximately, tract of land in Ector County, Texas, Odessa's county, and it's divided into two sections. The .229 acre section that was pretty clearly conveyed to PHH under both the original gift deed in October of 2009 and confirmed in the November 2009 second gift deed, the corrective instrument. What we're really talking about is the fate of the rest of that 1 acre approximately parcel, and whether there's a title defect with regard to the remainder of that parcel. And if there is a title defect, then my client has a valid and viable breach of contract claim, since Old Republic Title Insurance refused to pay on that claim. So we are only seeking money damages. There is no property right being adjudicated. There is no scenario in which the district court's judgment will result in a declaration of ownership of this land.
Is there binding, sort of clearly controlling law from the Texas Supreme Court that draws a distinction between a breach of contract claim in a title insurance case and an ownership, a trespass to title action? Is there a distinction in the case law between those two things? Because for me, that would be helpful.
Yeah, Your Honor, I'm not, as we stand here today, aware of an on-point Texas Supreme Court case, but I think just in terms of the relief sought, just as a matter of first principles, as a matter of first-year law school, contracts law and real property law.
I agree with you. What you say makes good sense. It's just that we're interpreting Texas law here, and we always would like to have the view of the Texas Supreme Court. But the other thing is, it strikes me that a consequence of your argument is that when you have a breach of contract claim based on title insurance, if the district court's view is right, you'd always have to do a Rule 19 analysis to figure out whether there are other parties who might have a property interest in the property that's covered by the title insurance.
I agree with Your Honor, and I think that would be a negative consequence of affirming the district court's ruling on the Rule 19, Rule 12.
Well, because, it seems to me there are two different, there's at least two different options for us. We can say, well, the district court's Rule 19 analysis was flawed, so send it back for more Rule 19 analysis. Or this is a title insurance case. Rule 19 is not appropriate in a case like this. And it sounds like you want us to say the latter.
The latter, Your Honor. I think that, again, is the straight line out of the maze, because otherwise it would gravely complicate the world of title insurance. If every time there was a claim against a title insurer, there had to be a Rule 19 analysis conducted and a possible bona fide purchaser for value brought in to the case, or whoever might be on the land, it would take what's a relatively straightforward industry that makes it possible to have commercial property transactions and really gum up the works and make it much harder to have meaningful title insurance coverage. And it would also bring a lot of third parties who don't want to be in the court system into the court system. And of course, I think it should be mentioned that it's not just my client who made the election only to litigate with Old Republic. Old Republic made the same election with regard to PHH. Old Republic could have brought in, third parties, whoever might claim ownership of this land. Both parties saw this as a straightforward insurance contract dispute and litigated that way to their cross motions for summary judgment. And I just think both in this case and based on this precedent, if there always has to be a Rule 19 analysis conducted in title insurance cases, it's going to put some sand in the engine of the title insurance industry and the commercial property industry.
So does the issue of title have to be decided at all?
I don't believe so, Your Honor. No.
So what happens after? So, I mean, between the two parties here, you exchange money, but how does the title get fixed or it doesn't?
So, Your Honor, if there is some future litigation on that, again, it's long ago enough in the past that I think there's probably some limitations issues. There may also be judicial admissions issues, and I think the time for these two parties to litigate against third parties was in this case, if either had elected to, they didn't. Both sides made that election to litigate only with each other, and the title issue will not be resolved by this contract litigation. Whether there's a live issue as to title, in a future case, that's a speculative question for another day, Your Honor. Your Honor, I should also mention that if the court agrees that the district court abused its discretion with its sua sponte dismissal under Rule 19 and Rule 12b-7, this is where the parties begin to disagree. I think my friend on the other side is going to pretty much agree with everything I've said to this point. Where we disagree is what happens next. My friend on the other side would like this court to adjudicate the cross motions for summary judgment that were filed in the trial court, but that were never adjudicated by the trial court because it engaged in sua sponte dismissal first. We believe that would be skipping a step. We believe that while this court has discretion to take on issues that were not decided by the title court, it should rarely, and only under exceptional circumstances, exercise that discretion, and this is not an exceptional case. This is not an exceptional circumstance. We, of course, are aware that review of grant or denial of summary judgment is de novo by this court, but it's de novo review, emphasis on that third word, review. It is still a form of review where you don't have to give you don't have to follow or give any deference to what the district court has done, but you do have that guide, that map that the district court has written for you. You review it. You review it without deference, to be sure, but you're engaging in review. What my colleague asks you to do is to be a court of first impressions and to make the initial determination on these cross motions for summary judgment. We believe that would be inappropriate, and it's something that almost never happens, although the court does have discretion to do so. The U.S. Supreme Court has used some pretty strong language on this, that resolution of an issue not reached by the district court should only occur, and I quote, where proper resolution is beyond any doubt or when injustice might otherwise result. And that's from a case called Singleton v. Wolf, 428 U.S. 106, pinpoint 121, 1976. There's no injustice that would result from sending this back to the Midland Odessa Federal Court to resolve the cross motions for summary judgment that are fully briefed and pending before it. Another U.S. Supreme Court case, the Hormel case from 1941, said this court should only exercise its discretion to take on an issue that wasn't reached by the trial court in exceptional cases. This is not an exceptional case. I see nothing exceptional about it. My colleague will argue that there's some judicial efficiency that might result from this court making that decision in the first instance.
Well, this is not a case where the district court did several pieces of an analysis and maybe left one aside that could have been an alternative ground. The district court did not engage in the summary judgment analysis as to the title insurance policy at all, right?
I fully agree with Your Honor. That's correct. That's the posture of the case, and that's why a remand to the district court.
Because we have lots of cases where we affirm on alternative grounds, but this, as you say, your argument is this case is quite different from that.
Yes, Your Honor, and I believe I've reserved a few minutes. And I
Yes,
appreciate
thank you. You do have 5 minutes for rebuttal. Mr. Colleluori? How's that?
Better than Kratovil even. That's
I should-
impressive.
I should have been an interpreter. All right. You may proceed.
Thank you, Your Honor. May it please the court. Mr. Kratovil is correct that in large part, I agree with the analysis that the district judge abused its discretion.
Do you also agree that in a title insurance case like this, a breach of contract case, that Rule 19 is really just sort of has no place?
It is, I'll say it this way, Your Honor, it is typically not an issue at all, and there's a lot of reasons for that. I do disagree with a few of the twists Mr. Kratovil put on his argument, but usually in a title insurance dispute like this, there has already been some adjudication of a defect in title, or there is a pending dispute, and the issue becomes, is the title insurance company going to defend, or if the title insurance company determines they agree it's a title defect, are they going to take affirmative steps to try to cure it somehow? So most of the time, the issue is taken care of by the facts and circumstances surrounding the dispute. And I'm not aware, and I've done title insurance litigation for a long time, of ever coming across a Rule 19 analysis like this being brought up. And obviously, we have the same issue that the appellant does with the district judge, number one, doing this sua sponte with no warning to the parties. Number two, not only determining that, A, he thought the case should be recharacterized as a trespass to try title, but also then determining that creates a required party, and then not even analyzing whether or not that party or parties could be joined, which is another part, obviously, of the Rule 19 analysis. So we all got caught sort of flat-footed by that decision.
Did the court, forgive me, I don't remember in the record, did the court sort of ask for supplemental submissions on this point?
He did not, Your Honor, and frankly, we expected, because PHH is sort of the master of their lawsuit, that they would raise this issue with the district judge, move for rehearing, something along those lines, if they intended to bring the third party in, because while I agree with Mr. Kratovil, I don't believe there is any risk of preclusive effect of a judgment in a title insurance dispute for just damages under the policy being preclusive on some absent third party. It does at least raise the prospect of potentially inconsistent judgments. That is an issue that I think PHH faces. So in other words, if PHH loses to us because we prevail on the theory that there is no title defect, they got the entire tract, and they then want to go litigate with somebody else, they face the prospect possibly of inconsistent judgments. And so we viewed this very much as a decision by PHH of what they want to do. And PHH has never advised us. We have no knowledge whether or not they've already decided that they're not, they've already acknowledged to the other potential owners that they're not claiming an interest. I have no way of knowing.
You agree, though, that with their framework, that it's an election of remedies kind of framework. In other words, this contract dispute and whatever the status of the title is are two different tracks.
It is, and it could be that they've already elected. It could be, as Mr. Kratovil says, he's made judicial admissions, or if he prevails, has some judicial estoppel issues, if he then tried to go take an inconsistent position against some potential absent landowner. All of that may be true. Ours is really, from our side of the V, it's a much simpler on-off switch of, is there a title defect?
But to do that, you've basically got to get to the heart of whether there's a title defect or cloud on the title and all that.
Absolutely. And while I agree,
So is it sort of like there's a trespass to try title action lurking in the breach of contract case, and the breach of contract case just subsumes it, or what?
I don't believe so, Your Honor, although the issue of title is certainly going to be at issue in our case as well.
I was going to say, for Old Republic to have liability, there needs to be a defect in the title.
Absolutely.
You've got to evaluate the title.
Absolutely. And
For Old Republic not to have liability, you've got to prevail in your position that there is no defect in title, you've got the whole parcel.
that's correct, Your Honor. And to go to Judge Duncan's question from earlier, I too am not aware of any case from the Texas Supreme Court or frankly the intermediate appellate courts that will tell you what's the limits of a trespass to try title action versus a suit on for breach for damages under a title insurance policy. I agree with what everybody else said, which is, fundamentally those are different things.
And it does seem logical to Judge Duncan's point that that you wouldn't need to join every possible title holder as opposed to, like, basically that's why you'd have a cloud on the title if there are other potential holders out there if you have a dispute with your title insurance company.
Correct.
In other words, that sort of grossly distorts the claims process.
Correct, although again, I will go back to what I said earlier, which is that
It's just unusual because usually
right.
all that precedes.
typically that is already decided somewhere by court, or it is actively being litigated as part of the is there coverage and under a duty to defend, or we have the right to try.
But it is quite a different thing to say you have to do that before you can really get to the heart of a breach of contract claim.
That's correct, Your Honor. And obviously a trespass to try title claim is in rem essentially, and everyone, it's against the world essentially, whereas this is not. This is a claim simply for damages. And so, again, I think there is the prospect of PHH exposing itself to inconsistent judgments by the way it has proceeded, but that's not really our issue, so long as we can have adjudicated that we believe there is no title defect as a matter of law, and therefore there is no liability, that it's up to PHH who they want to proceed against, when they want to do that, or if they even still retain the ability to do that. But I do believe I would give the district court this much. Under the unusual facts of this case, certainly the other potential landowner could be a proper party. There's no question about that, given the way this case is postured and how it came in as a claim on the title insurance policy. But that's a very different question than are they a required party, and are they an indispensable party, and can they even be joined if the court thinks they are one, none of which have been answered by the situation we have right now. So we agree it needs to be reversed. Whether that is, we don't really think they're a necessary party, but if the court felt that's something that should be addressed in the proper Rule 19 methodology by the district court, you've got that option as well. And of course, there's the third option, which, as Mr. Kratovil said, I was going to advocate for. And believe me, I understand that is far from the norm, that this court ordinarily will not pass on an issue that hasn't been decided by the district court. But at the same time, those cases always say the court does have discretion to do so, and the reasons why we would submit that discretion could be exercised in this case are a couple. Number one, it is a pure question of law at this point. There are no disputed facts. Even the district court's Rule 19 order recites the undisputed facts as they were posited by both parties in their cross motions for summary judgment. The only question we have is what is the legal effect of that second deed? And that question boils down to simply, what does the statute mean? What does section 5.028 and 5.029 of the Texas Property Code mean? And all that was teed up with no one suggesting there was any disputed fact question to be had on that. Fully briefed, we were past the close of discovery. The only thing left was the trial on the case after dispositive motions, and the court district judge decided not to engage on that issue at all. So it is not the type of thing that many of the cases talk about where either the district judge didn't have an opportunity to consider it, the parties haven't fully briefed it, there may be embedded factual issues. None of that is present here. It's a pure question of law and statutory interpretation. The second point, and I'll be frank with the court, this is just purely practicalities. This is not legal, this is practicalities, which is, this is not a very big case at all. It's a $100,000 title insurance policy. As the court knows from our briefing, we don't think there's any damages, there can be any damages, even if there were liability. But if there were, they're going to be minimal. And the thought of putting the courts and the parties through the process of going back down to the district court to do it all over again, to come back up to this court.
Well, that suggests settlement might be a really good option. I mean, the problem with cases that may not be big cases is if we write the wrong precedent, they become really big cases for the next ones.
I understand, Your Honor, and as I say, I know this is not the norm of what I'm asking for, but it is.
Well, how extensive would the proceedings have to be on remand if we did do that?
Well, I guess that would depend on a couple of things. Number one would depend on whether or not you're remanding to the district judge for a full Rule 19 analysis or doing that by yourself on the first instance. Second, if the judge, I guess it's conceivable, given what we had in the Rule 19 order, that he doesn't grant either summary judgment, and then we may have a trial, or he might grant one of the summary judgments, and we have a trial on damages. And then we know, because both parties were willing to come to this court already, we know that whoever loses that is coming back to this court for another appeal. And as I said,
Parties agree that there are no contested facts?
excuse me, Your Honor.
Do the parties agree that there are no disputed
I believe
material
I'll
facts?
let Mr. Kratovil respond in his rebuttal, but I believe, I may be mistaken, but virtually everything that's relevant to the liability issue, the damages issue may be a little bit different, but on the liability issue, I think both parties put the same exact, or very close to the same exact set of undisputed facts in their cross motions.
Okay.
I will, if the court's indulgence, then I will just briefly touch on the merits, recognizing I have, get you to the idea of wanting to reconsider them at all at first. But I do want to point out what should be obvious, I think, from the briefing and the record, to the extent the court's had a chance to review it already. This so-called correction deed, the second deed, is nothing but a photocopy of the filed first deed in which someone has interlineated, and we have no idea who, 0.229 acres out of that was then the described tract as set forth on Exhibit A. And then an Exhibit A was attached with a meets and bounds description of 0.229 acres. That cannot satisfy the Texas correction statutes, and the reasons are set out fully in our brief. I won't belabor it, but that is undoubtedly a material correction under 5.029, and we know that because 5.029 says that. It says one of the examples of a material correction is to correct the deed to remove land that was conveyed in the original deed, where as long as it was conveying otherwise correctly conveying some part of the land. So it is a material correction. The Midway Solar case that we cited in our brief says that as well. Since the briefing was done just a month or so ago, another case out of Eastland called Gaskins versus Navigator Oil. That's 670 Southwest 3rd, 391. Also reiterated that a correction instrument that alters the extent of the property being conveyed is a material correction, and that can only be done under 5.029. And importantly, PHH does not claim they satisfy 5.029. They're instead trying to shoehorn this into some sub-provision of 5.028 as what can be done as a correction affidavit normally, or it's called a correction instrument in general, but it's normally done by affidavit. And those are, per the terms of 5.028, intended for simply clerical type changes, mistakes made in a legal description, wrong plat number, wrong page number, wrong lot number. That's not what we're dealing with here. And so this can't be done under 5.028 because it's material. But even if it could, just like in the Midway Solar case, this correction deed in no way, shape, or form meets the requirements of 5.028. As I say, 5.028 is normally done by an affidavit because the statute says it has to be executed by a person with personal knowledge and disclose on the face of the instrument the basis of that knowledge as to what the nature of the correction is and why. And then it has to be copy sent to the grantee, if he hasn't otherwise signed it, to make sure, even though it's non-material in the terminology of 5.028, to make sure that at least he's had notice that this change is being made. I invite the court simply to look at the correction deed that appears in the record. It doesn't do any of that. We don't know who prepared it. We don't know what basis it was. We don't know why anyone would think there was an error in the original. For all intents and purposes, anyone could have pulled a copy off the deed records and made that interlineation and refiled it. And that simply can't satisfy the statute. So, again, we think it's a fairly straightforward question that can be easily answered. It's a purely legal question. It would indeed very much be in the interest of judicial economy and efficiency, but I understand the court has discretion and normally does not do that, but I would be remiss if I didn't at least make the request. And with that, I'll cede back the rest of my time, Your Honor.
Thank you, counsel. You have time for rebuttal, Mr. Kratovil.
Thank you, Your Honor. I wanted to pick up on a theme that was expressed in one of the court's questions. While this is monetarily a small case, it is an important precedent. That's why I think both of these clients are here. Both PHH and Old Republic are regular players in this space, and so this will be a meaningful precedent in this industry. That's why we're here, not the monetary size of the case. And if a Rule 19 analysis needs to be conducted every time one of these cases is in front of a federal district court, that's going to complicate life for some lawyers in the trial courts.
Title insurance prices might go up, huh?
I won't speculate on that, Your Honor, but it seems a fair point. Second, de novo review is still a form of review. And whether it would be efficient to skip the district court and for this court to rule in the first instance, sure, that would be efficient, but it wouldn't be performing de novo review. It would be sitting as a trial court, in effect, and taking a job that needs to be performed by the trial court. Your Honor asked about the size and scope of this remand. I don't think it needs to be the world's most complicated remand. These motions, cross motions for summary judgment, are fully briefed and pending, and the trial court can make a decision on those. That decision may end this litigation, or as counsel noted, it may lead to a trial on at least damages. But I do think it is important since this court has been invited to perform the district court's function and rule on summary judgment, that ruling on summary judgment does not necessarily end the case. So even if this court were to accept that invitation, exercise its discretion to rule in the first instance on an issue, there might still be a remand, which augurs against this court taking that exceptional step of sitting as a trial court and ruling on summary judgments in the first instance. I think ownership is a question for another day. This is a money damages breach of contract case, and counsel had some comments and some thoughts about how my client had elected to litigate this case. My client is the master of its complaint. My client is the master of its lawsuit. It believed this to be the most efficient way to litigate a breach of contract lawsuit against one party rather than, as counsel put it, an in rem action against the world. So I think my client, given the monetary value initially, was trying to be as efficient as possible. Now, things got a little more complicated with this Rule 19 issue and the important precedent that it will set. But by teeing the case up this way, I think it was an election of remedies, and my client was trying to proceed efficiently and in a linear fashion under a contract theory rather than a much more potentially complicated in rem action on the title question. Your Honor asked if there were any disputed facts. And I do think, I don't want to try to give my summary judgment argument here. We'll stand on our briefing on summary judgment as well as our summary judgment briefs in the record. But as to 5.028, I think there are some disputed facts. Counsel mentioned personal knowledge, whether the person filing the second gift deed had personal knowledge. We think that's a factual dispute. Also, and I think this needs expressing, the second gift deed was in 2009. The Texas Property Code with 5.028 and 5.029 was amended in 2011, but made retroactive. So while 5.028 and 5.029 do apply to this dispute, they apply retroactively. And that's important for summary judgment purposes because it means that there needs to be substantial compliance, not strict compliance. If we had been after the amendment, I think counsel is right. There would need to be strict compliance. And I don't know that the second gift deed does strictly comply with 5.028. I do believe it substantially complies to that retroactive statute. And because no one has a time machine, we can't demand strict compliance for a statute that's passed in the future and made retroactive. So that substantial compliance, that's what we'll be talking about in the district court on summary judgment and what we've talked about in the papers already. But I do think at the end of the day, a remand for the district court to do its work and adjudicate the two cross motions for summary judgment is what we would ask of this court.
Okay, thank you, counsel, for
Thank you, Your Honor.
a well-argued case on both sides. We'll take the case under submission. And while you clear up, we will call the next case. Number 22-20436, Perry.